Okay. Welcome to the Office of Tax Appeals. I want to thank everyone for attending today. My name is Josh Lambert, and I'm the lead administrative law judge for this hearing. My co-panelists today are Greg Turner and Seth Elsom. All three of us will meet after the hearing and produce the written opinion as equal participants. Before we go on the record, I want to discuss a couple of things. The Office of Tax Appeals is not a court, but an independent appeals body. The office is staffed by tax experts and is independent of the state's tax agencies. Also present is our stenographer, Ms. Alonzo, who is reporting this hearing verbatim. To ensure that we have an accurate record, we ask that everyone speaks one at a time and that they do not speak over each other. Please speak directly into the microphone and mute your microphone if you're not speaking. Also, please speak loudly and clearly. When needed, Ms. Alonzo or the panel will stop the hearing process and ask for clarification. After the hearing, Ms. Alonzo will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. And to use the microphone, there's a push button, and when it's green, it's on, and you can turn it off when you're not using it, and just get close enough so that we can hear it on the live stream. And also, I wanted to double check, prior to the hearing, we gave appellants 60 minutes, so I want to check with FTB if they required more time also.
I don't think we need more time.
Okay. Were there any other questions before we go on the record? Ms. Alonzo, are you ready to proceed? Okay. We are now on the record in the Office of Tax Appeals oral hearing for the appeal of James O'Hara and Cynthia Weldon, case number 2207-10945. The date is June 18th, 2025, and the time is 10:27 a.m. My name is Josh Lambert, and I'm the lead administrative law judge for this hearing, or lead panel member for this hearing, and my co-panelists today are Judge Turner and hearing officer Elsom. First, we'd like to have everyone introduce themselves, so FTB, could you please introduce yourselves for the record by stating your names?
Jackie Sumaida for Franchise Tax Board.
Chris Cook for Franchise Tax Board.
Thank you. And for appellants, could you please introduce yourselves?
Chris Campbell for appellants.
Hannah Kim for appellants.
Thank you. Thank you all for attending. The issues in this appeal are whether OT has jurisdiction to determine whether FDB properly calculated the amount of accrued interest on the undisputed tax deficiency assessment. And the second issue is if OT has jurisdiction, whether appellants have shown error in FTB's computation of interest. In terms of exhibits, FTB provides exhibits A through E, and appellants provided exhibits 1 through 7, and I believe FTB provided some kind of document before the hearing. Is that just like a summary of a timeline?
Yes, Judge Lambert. It's not submitted for evidence. It's to assist with our presentation, just a visual aid.
Okay. And the appellants have a copy as well?
Yes, we provided a copy with appellants.
Okay. Or appellants representatives. So just to double check, FTB, were there any objections to appellants' exhibits?
No objections.
And were there any objections to FTB's exhibits, Mr. Campbell?
No objections.
Okay. So that evidence is now on the record. First, we will start with appellant's presentation. So we decided on 60 minutes. So, Mr. Campbell, this is your opportunity to explain appellant's position, and you can proceed when you're ready.
Thank you, Judge Lambert. Is that loud enough? Yeah. How's that? Better? Okay. First of all, thank you for being here. We're pleased to be here as well. I'm going to preface this. I'm going to go very slowly. Hopefully I don't need the full 60 minutes, but I asked for that because there's a decent amount of material that I wanted to go through with everybody, slowly, because it's important to see the framework of all the statutes. So if we don't need 60 minutes, that's great. Okay, so we have two issues, as you mentioned. One is the jurisdiction issue, and the other one would be the merits, which is the method of computation of interest. Before getting to those, I wanted to go through the facts briefly, the agreed facts. All the facts are agreed and well stated in the FTB's brief and in our brief. But I'd like to direct you to the table, if possible, that we have on page 4 of our reply brief, which is the March 28 brief, because I think that's just as a visual aid really helpful here. And then I know the FTB submitted something that they'll use. It's also visual. But if I may, whether you have it or not, there's two tables on the page. There's the upper table and the lower one. So the issue here is the computation of interest on a deficiency that was assessed for the 2017 tax year. Basic facts, again, 2017 tax year, the taxpayers filed a return reporting tax due of $2.9 million. I'll just use the round numbers, which is at the top. And the overpayment on the return to the next year, which was elected to be credited to the next year, of $3.7 million. 2018 return reported tax due of $1.279 million, and again showed a overpayment of $3.030 million. And then in 2019, that return, 2019 tax return, showed a tax due of $1.8 million and an overpayment of $1.2 million. So those are the returns that were filed. In 2021, the FTB audited the 2017 tax return and notified the appellants and us of the audit, and immediately they explained that the issue was the claim of another state tax credit in the amount of about $2.2 million for taxes paid to Iowa. As soon as we got that information, we looked at the returns and realized that that was a complete error, just unintentional error. We informed the FTB auditor and explained that we'd make a payment, and the auditor agreed to close the case and issue an NPA. So the taxpayers made the payment of the $2.269 million on March 22, 2021. It's shown on that same page 4. It's also in the briefs. And that was, again, March 22, 21. What's important here is then to look at the NPA, which was then issued after the payment. This is Exhibit 3 to, excuse me, I'm going to move this. Exhibit 3 to our appeal. And I just want to point out that again, this is issued June 10, after we made the payment. And it shows notice of proposed assessment of $2.627 million, which includes the additional tax of $2.69 million, about 3/4 down the page. And then it says interest to June 10, 2021. And then it says, again, acknowledging the payment, your web payment of $2.269 million will be credited to your account effective March 22, 21. The total additional tax and interest shown on this notice does not include the payment. The payment will be applied as of the payment date and interest adjusted when the notice is final. If a balance remains, additional interest will be charged until the balance is paid in full. When we saw the NPA and the $358,000, we thought, wow, that's really overstated. That doesn't make sense. We had overpayment funds, as of the end of at 4/15/2018, which is the date taxes are due for the 2017 tax year, and going forward, we always had overpayment. So our immediate response, and even though the NPA says it's an estimate, it's going to be adjusted, the point is the NPA doesn't even include a correct computation, right? So we've paid the tax, and now we have an NPA that we have to protest. And we protested just the interest computation. Said, look, we need to make sure that the overpayments are taken into account, which they should be. There's no dispute that overpayments get taken into account. So we filed the protest, and during the protest, we had a lot of back and forth. Some of the protest correspondence is in the FTB's brief as exhibits, and that's fine. That led to there were some revised interest computations. Again, the FTB had to recompute interest, and they had it one way, and then they do it another way, which we'll get to take into account overpayments. So they had to make adjustments because it was incorrect to begin with. And then at the end of the protest process, we still disagreed with their computation, and so we agreed to disagree, so to speak, and then they issued a notice of action, and that's Exhibit 1 to appellant's appeal. And again, the notice of action itself says this is affirmation of our response to the notice of proposed assessment issued 6/10/2021. There's a proposed amount of tax or balance due of $2.7 million. It says additional tax of $2.269 million, interest to 6/27/2022. Now it's $442,000 of interest for the total balance of 2.7. Again, on the notice of action itself, they explain that during the protest we dealt with interest, and it says it was determined that the FTB correctly calculated the interest on the additional tax based on the May department store decision. Then says the 2.2. Sure. Oh, sure. Sorry. I'll try. I wanted to go slowly, so thank you for telling me to slow down. Everybody get that so far? Okay. So again, yes, I apologize. I'm reading, but it's important. The notice says $2.269 million will be credited to the account effective March 22, 21. So again, they're still telling us that this will happen in the future. The total additional tax and interest shown on this notice does not include this payment or interest calculated in accordance with May, which is exactly what they said that they had determined in the protest. Once the notice becomes final, all payments will be applied and the interest will be determined as discussed during the protest. Interest is charged to the date of your payment. If a balance remains, additional interest will be charged until the balance is paid in full. So again, just pointing out that we've made a payment, we have a protest process disputing interest. The notice of action, which, again, I'm not claiming that there's a problem with it. It just, the way this works is that interest is not even finally determined or computed until well after the process is done. That's going to be important. So that was issued on June 27. Again, we had paid the tax balance of that 2017 deficiency on March 22, 2021. And the way the FTB does it, as we'll see, they continue to charge interest. They had assessed interest, or they had said there was an estimate of interest back in 2021. They continue to assess interest on the balance the way they compute it. And so as of the time of right before the notice of action, there was still a balance of approximately $240,000 or something, which we paid on June 22, right before the notice of action. The point of that payment was just simply to cut off any amount that the FTB said was due at this time so that no more interest would accrue under the way they do it. So let's turn, so again, none of this is disputed, this is all in the record. Turn to the second table in our on our page 4. And this shows, purpose of this is important because it shows the effect of the payment that was made, the deficiency that was assessed, and the payment that was made on March 22, 21. And it goes to how we will show that the statutes work to compute interest. So when you take the $2.269 million deficiency into account back in 2017, the correct amount of tax that was due was $5.2 million. And again, since we were overpaid by several $1 million, the remaining overpayment balance as of April 15, 2018, when 2017 taxes were due and payable, was then $1.49 million. Rolling that forward to 2018, we now had the reduced overpayment, and nothing changed on the 2018 tax return. It's just that the overpayment at the end of that year becomes $761,000, which is then rolled over to 2019. So we have an overpayment as of 4/15/2019, which is important because that's what we'll come back to. And then in 2019, again, we have the tax due of 1.8 million, and our reduced overpayment causes us to have on April 15, 2020, the date that tax is due for the 2019 tax year, we now are deficient to the extent of 1,040,626. Again, so then we paid the deficiency on March 22, 2021, and that's why we show, as we will show, the statutes impose interest beginning on 4/15 of each year if there is tax due and unpaid. The first time tax is due and unpaid on April 15 is April 15, 2020. We then have a deficiency. Our payment was made in 2021, so interest can accrue on the amount that's due and unpaid, which is the 1,040,000 through the payment date, and we'll get to that in a minute. But these are, just using this to show the facts as to what happens when we apply the deficiency and credit overpayments. Okay, the last piece of the facts is going to be what the FTB's computation is, which is Exhibit C to their brief, I think page 6. So I hope everybody can have this before them. But this is the interest computation that that their final one from the protest, attached to a November 18, 2021 letter. And you can see that there is agreement, and the point of this is to show, this whole presentation is to show that the facts are agreed, the facts that matter are agreed. So quarter down the page on the right side, you can see that with the May Department, store analysis, they start with a revised overpayment balance of 1,490,237, which is the amount shown on our table as well. So we all agree that we're overpaid on 4/15/2018 to the extent of 1,490,000. The FTB then takes that overpayment balance and applies it to required estimated tax payments going through the year, and they get to a number, an overpayment at the end of as of 4/15/2019, effectively for the 2018 taxable year. You'll see the $889,000 number. That's so their point is that there's $889,000 of overpayment still available as of 4/15/2019. They're doing it differently than we do. The actual overpayment, of tax dollars, not taking into account estimates, is the $761,000 shown on our table. So this is why, if you read, in our briefs, for example, there's a difference in the interest that they are assessing to us and which is what we paid on June 22, 2022. And there's a footnote 2 in our brief that just explains, since we paid more than we actually owe in interest, we have a refund claim before you as part of this. Okay. So I think that's good for the facts at this point. Let me pause. Questions on the facts? Okay. Do you have before you the two tables, just because I think it's important to visualize all that? Okay, great. Okay, so turning to the issues, I'm going to go first to jurisdiction, so just give me a minute to get my folder here. told you I would go slow, so just bear with me. I hope that's okay. Okay. So after briefing was complete in this case, the OTA sent the parties a letter on October 4, 2023, requesting the parties to submit briefs discussing if the OTA has jurisdiction to determine whether FTB properly calculated the amount of accrued interest on the undisputed tax deficiency assessment of $2.2 million. And that letter went on to discuss statutes and cases that deal with interest abatement. Because interest abatement, as we'll talk about in a minute, has a specific standard of review before the board, before the OTA. This is not an interest abatement case. So, seeing that, we responded the very next day with a letter setting out the reasons the OTA has jurisdiction expressly under their statutes that implement or that establish the OTA and by the rules, OTA's rules, and then even some cases. So the FTB then responded in February, a couple months later, and even though the OTA had raised this sua sponte, they now grabbed onto the issue and said, OTA does not have jurisdiction to hear and decide an appeal relating solely to unpaid interest on a deficiency because interest is not included in the legal definition of a deficiency. And then they cited a case that also has to do with a statute that's not applicable here, which we'll get to in a minute. But the issue of whether it's included in the definition of deficiency is not going to be germane, as we'll show. So that's how this came up by way of background. And the OTA clearly has jurisdiction, and I'll go through that. Okay. This is where I need to go kind of slowly. And I submitted as a pre-hearing, kind of supplement the interest statutes for everybody to have handy. It's not an exhibit, it's just the law, but it's helpful to have them all, in order from the code, which we'll go through in a minute. So the government code established the OTA in 15671 and 15672. You're the successor to the board. You have jurisdiction to do everything that the Board of Equalization did, including here appeals from actions of the Franchise Tax Board under Part 10.2, which is where we are. More specifically, your regulations give you, jurisdiction expressly. Section 30103 of your rules says, in general, OTA has jurisdiction to hear and decide an appeal that has been timely submitted to the OTA pursuant to OTA's rules for tax appeals, if any of the following circumstances apply. Number one, FTB mails a notice of action on a proposed deficiency assessment of additional tax, which may also include penalties, fees, and interest. I'll pause here because that is exactly what we have. If you go to the notice of action, which was Exhibit 1 to our appeal, again, plain, the FTB mailed a notice of action on June 27 within 2022, with an appeal by date of 30 days later, showing a proposed amount of tax, additional tax of $2.269 million, and interest, again, which was not correct, and it was an estimate and way overstated of $442,000. So, the jurisdiction here is simply based on the mailing of a notice that assesses, let me read the specific language again. Notice of action on a proposed deficiency assessment, which is what this was, of additional tax, which may also include penalties, fees, and interest, and which it does. Other sections in 3103, also provide that you have jurisdiction to determine, tax, interest, penalties, and fees separately. And those are all, things within your jurisdiction. 301033. FTB mails a notice of action on a cancellation, credit, or refund. Again, mailing a notice of action on. The whole point is the FTB's made a determination against the taxpayer, and the taxpayer is bringing it to you to review it and determine whether that's correct. That's what this is. And I think at this point I can simply say there is nowhere in any of these statutes that make your jurisdiction dependent on whether a tax is in dispute or not when it comes here. That's just not there. So everybody would concede, the FTB is agreeing, that you have jurisdiction to determine whether a computation of interest is correct under these statutes if the tax is also in dispute. So it just simply doesn't make any sense. FTB issues notices of interest assessments, whether there's a tax due or not, on a regular daily basis. Probably you get interest if you underpay your tax on your return. You get a notice that says, hey, you owe additional amount plus interest. You self-assess an additional amount that you owe. If you get a deficiency assessment and you dispute the tax and there's an interest, that's in dispute as well, and it's also before you. 3103 also says you have jurisdiction if the FTB mails a notice that disallows interest on a refund. That's purely relating to interest. If I've asked for a refund and they don't allow interest or the correct amount of interest on the refund that I've requested, I can appeal that to you. Okay? So you have jurisdiction, under the government code and expressly under your own rules. It's not dependent on whether a tax is disputed as well. And by the way, that wouldn't make sense because the whole point here is that whether it's at audit or before a hearing, everybody wants to get tax resolved as early as possible. It doesn't make sense. The FTB is saying here that, okay, if you agree to the tax or if you just get an assessment of interest because and again, which is way after the fact, these interest determinations are wrong as we're seeing on the NPAs and NOAs. They're not correct. They have to be redone. They are saying if that's the only thing in dispute, then taxpayer, you have to pay that interest, file a claim for refund, have the claim for refund denied, and then file a complaint in court and sue for refund and wait to hear your case before a judge. But that doesn't make sense. And again, nothing makes your jurisdiction dependent on a tax deficiency, a tax being in dispute as well. So I'm going to pause because I think most of the cases that come before you involve interest abatement. And so probably that's why the OTA sent the initial letter and cited interest abatement statutes and cases. And again, this isn't an interest abatement case. So let me just walk through the interest statutes briefly. Well, sort of briefly. And I'm going to use the copy that I sent, in that pre-hearing letter on June 3, 2025. But it's just the law. I just got to find my notes. Where's your outline? Okay. So the interest, there's an entire Article 6 in the code called interest. And it starts with 19-101, which is the statute that it matters here. And that statute says if any amount of tax imposed by Part 10 or Part 11 is not paid on or before the last date prescribed for payment, interest on that amount at the adjusted annual rate shall be paid for the period from that last date to the date paid. That's the first statute in the section. It imposes interest. Then there's a slew of other statutes that continue. Some of these provide very specific rules that say, okay, we have imposed interest per 19-101, and interest cannot accrue, we'll see, in certain circumstances. other statutes, namely 19104, 19109, 19112, are statutes that deal with requests for abatement. And those statutes, just looking at, start with 19104, I'm sorry to belabor this, but I think since you see interest abatement cases so much, I think I'm just going to present it, and hopefully it doesn't take too long. 19104A, FTB may abate interest on a deficiency to the extent it's attributable in whole or in part to any unreasonable error or delay on their side and not attributable to the taxpayer. It's effectively what A says. And then subsection B says for purposes of subsection A, and then you get down to B2B, the state board, now the OTA, shall have jurisdiction over the appeal to determine whether the FTB's failure to abate interest under this section was an abuse of discretion and may order an abatement. Okay, there's a specific standard of review that applies to an abatement case. Why? Because the FTB is given broad discretion to determine whether to abate interest. Again, they have to look at their records and determine whether there were delays that were not attributable to the taxpayer. And, if they grant that, you can review that, but it's only for abuse of discretion. The same as in 19109. The language, 19109, B2B again, board shall have jurisdiction over the appeal, determine whether the failure to abate interest under this subsection was an abuse of discretion. This one pertains to disasters. If there's a disaster that causes a problem for a taxpayer. And then there's 19112, which you had a case on recently, which is what the FTB cited. This statute actually provides for waiver of interest, not abatement, waiver for any period for which the FTB determines that an individual or fiduciary demonstrates inability to pay. Last sentence of that section, any waiver under this section shall be withdrawn retroactively if made. Oh, wait, sorry. Apologize, strike that. Interest may be waived. It's the FTB determines that on their own. You held, and there makes sense that there's no authority, no jurisdiction here to review. Really, a taxpayer doesn't have standing to ask you to review. Sorry, I'm slow. I got to slow down. A waiver of interest. Okay, so you have 19104, 19109, 19112, all of which have baked in standards of review. Why? Because it's the FTB's discretion to grant an abatement or to waive in the first place. All of these other statutes, starting with 19101, 19105, 19107, 19108, 19110, 19113, okay? They all have different language. These are mechanical, very specific statutes that tell the FTB and the world when interest is imposed and when interest must not accrue. So just, again, we already read 19101, 19105, and they all have the same language that's important, distinguishing from the abatement cases. 19105. Interest, in the case of an individual fiduciary, FTB shall not assess interest charges pursuant to 19101 for the period between 45 days after the date of final review of an audit determining an additional amount is owed and the date a notice of proposed deficiency assessment is sent to the taxpayer. So there's a period where interest shall not be assessed. FTB shall not assess interest. Okay, that's a mandatory provision. The FTB has to do that right. 19107. Overpayment by an individual and deficiency in the same year. Last clause, no interest shall be assessed on that portion of the deficiency as is extinguished by the credit for the period of time subsequent to an overpayment. It's the no interest shall be assessed language that you will find in the circumstances described in sections 19107, 108, 110, and 113. So again, the point of going through those statutes, Article 6 specifically deals with interest. There is a statutory scheme. If interest is imposed under 19101, that's the starting point for everything. A taxpayer can request abatement. That's their discretion, FTB discretion, and there's a standard of review for that. All these other things are mechanical, and it has to be done right, just like tax has to be computed right. Okay. And again, the policy here is there is simply no, in the statutes and rules, there's no, your jurisdiction to review these interest computations is not dependent on whether the tax is also in dispute. I mean, that's, doesn't make sense, as I said before, to have to go to court just to contest interest after you've agreed to tax. And by the way, if tax is settled on the, or resolved first at the OTA, is the idea that we would no longer be able to contest interest. I mean, that, again, just doesn't make sense. So again, it's just not in the rules. Questions on jurisdiction?
We'll probably save all our questions till after the full presentation.
Okay. And I guess I should add, again, when the FTB responded in February to their jurisdictional, this question that you posed, their statement was that you don't have jurisdiction to hear and decide an appeal relating to unpaid interest on a deficiency because interest is not included in the legal definition of deficiency. So even that issue, the way they're phrased it, wasn't focusing on whether the deficiency was in dispute or not. Again, they'll probably explain. I just am reading their issue, their statement of their issue as interest not included in the legal definition of deficiency. And again, the definition of a deficiency is in a completely different set of sections that deals with determining deficiencies. That's 19043. And that is simply that it's the amount shown on a return and the amount that's actually due. If there's that's what is a tax deficiency. Interest, of course, is then assessed on any deficiency, and that's separate. And in the interest statutes themselves, I think it's 19114. I think. Hold on. It says, interest prescribed under this Article 6 on any tax may be assessed and collected at any time during the period within which the tax to which the interest relates may be collected. So again, the fact that deficiency relates to tax, just doesn't have any impact on this issue or whether you have jurisdiction. And again, your jurisdiction in 3103 exists when the FTB mails a notice of action on a proposed assessment, which may include, interest fees and penalties, and then there's other sections there as well that raise interest. So that, I think, concludes the discussion of jurisdiction. I'm going to pause again so I can get together the stuff for the merits. Sorry, thanks for bearing with me. Okay. Going back to the facts, which I said at the beginning, at the end of the day, what's in dispute here? Our position is that the law 19101 provides that interest may be assessed, must be assessed, or is assessed if any amount of tax is not paid on or before the last date prescribed for payment. Interest on the amount shall be paid for the period from that last date to the date paid. So that statute, the plain language is clear that interest begins to run on April 15 of a particular year. And that's because statutes that we all agree on, won't go into unless I need to, provide that taxes are paid on April 15, are due and payable on April 15, and all payments are applied, even estimated taxes are applied on April 15, and that is when you determine whether the amount of tax you've paid is more or less than the tax that is imposed. And in this case, 2017, taking into account all the payments that had been made and the correct tax that was due, there is an overpayment of $1.49 million. We all agree with that. Okay, so there's no dispute. And I think the point is, again, that we're going to come back to this is a determination that is made on April 15 of each year. In our table, we show that under the plain language of this statute, the interest statute, there is no tax due and not paid on April 15 of 2018 for the 2017 year. Again, the FTB agrees. Or on April 15, 2019, which the FTB actually agrees to. They just say interest begins to accrue then, but they agree there's an overpayment at that time. And the first time that there is not an overpayment where taxes actually due and not paid is April 15, 2020. So that is why our application of the statute is that on April 15, 2020, there is now a tax due and unpaid of $1,040,626 that needs to be satisfied. Interest can begin to accrue at that time, April 15, 2020, and it is interest accrues shall be paid for the period from that last date, April 15, 2020, to the date paid, which in our case is March 22, 2021. That's, as we said, 341 days. So we calculated that our interest based on the FTB rates was about $37,981. Again, the way the FTB does it, they computed it was about $240. We'll get to that in a minute. But the plain language of the statute is simply that, April 15 is the date that interest can begin to accrue, and only if you have an amount that's due and unpaid, and we just don't on 4/15/2018. So if I were just slow down and state the very specific issue and the answer, the FTB's position here, which we'll get to, is that interest begins to accrue on April 15, 2019. And we'll go through their analysis of why that is, but it can't be because under the plain language of the statute, there is an overpayment as of that date. No tax is due and not paid on April 15, 2019. So the plain language, says interest does not begin to accrue at that date. It's just you can't apply that language there. You can as of 4/15/2020, which is what we do. So there is approximately a year there in dispute. But in addition, I'll get to the FTB's position here, which is shown on their Exhibit C. And let's just take a look for a second. In the far right column of their Exhibit C, page 6, you will see as you go through, they agree that we have an overpayment on 4/15/2018, again, of $1,490,000. And then they use that to satisfy some payments for estimated taxes that we'll talk about, which is the confusion here. And then down on April 15, 2019, about 3/4 of the way down the page, you'll see the remaining overpayment at the end of the 2019, as of 4/15/2019 of $889,000, and they move that over to the next year, and then they reinstate the entire amount of the deficiency of $2,269,115, and they start charging interest on that entire $2.2 million on April 15, 2019. I hope that just saying that shows that that makes no sense. We have overpaid to the tune of $889,000 under their own theory, and what we'll get to is what they're doing is not in accordance with the law. But the fact of the matter is, certainly there isn't $2.269 million due at that time. They just satisfied the $2.269 million and said we owed $1.49 million and are applying that amount to go down. So that's not right. That's why, we paid that full amount of like $240 and said that we really only owed $37, so that's what the refund would be. So the difference in our positions is not just the accrual date. They want to start the interest accruing on April 15, 2019, and we're starting it on April 15, 2020, but they're also accruing interest on the entire amount as if it were not paid. And it was. So, again, our case is pretty straightforward and simple. Just another, harks back to what the May court said about the taxpayer's case. It's in our table. It's simply based on 19-101, which is very specific and just focuses on April 15 of each tax year and whether there's an amount due. The entire confusion and position here and this computation on Exhibit C is all based on the incorporation of certain part of the estimated tax payment regime. Those statutes just don't apply here, and they don't, they're not relevant to this computation, to the interest computation. And that is, there's cases directly on point, which I'll get to. But let me read, just to set the stage. Again, I just want to be clear. I'm going slow and being repetitive. I apologize. Our case and the simple application of the statute is in our table, lower table on page 4. Everything else now is going to be discussing what the FTB is doing and why that's not correct under the statutes. Okay, so let me just read read the position and then I'll read some of the passage from the case that deals with it. So the FTB's position in their January 3, 2022 letter, part of the protest determination, where they're affirming, again, this computation on Exhibit C. The FTB on page 2 of 4, which is page 2 of FTB's Exhibit D, the FTB did not charge interest during the period from April 15, 2018 through April 15, 2019 because the taxpayer's 2017 tax liability was determined as of April 15, 2018, and upon filing their 2017 return, the taxpayers determined they overpaid their 2017 tax liability and elected to have their overpayment applied towards their 2018 estimated taxes. The FTB started charging interest as of April 15, 2019, because the taxpayer's 2018 tax liability was determined as of April 15, 2019, and the FTB no longer had use of the taxpayer's overpayment after April 15, 2019. Therefore, as of April 15, 2019, the taxpayers could elect to have their 2018 overpayment of $3 million returned or apply it towards 2019. Okay, just pause there. Again, this shows that we all agree that tax payments are due and applied and determined on April 15. But there's this, the statement that we have an overpayment in 2018, but when we get to April 15, 2019, that the FTB no longer had the use of the taxpayer's overpayment, they did. And the courts, we'll get to say that is important and it doesn't allow interest to accrue. So they absolutely had the use of our money on April 15, 2019. Again, what this goes to is going to be this theory about this credit elect statute, which we'll get to. They then say in their brief, just to drive it home, to be clear, this is on page 7 of their brief. To be clear, when the FTB computes a deficiency for an initial tax year and a credit elect was not fully needed to satisfy estimated tax installments for the subsequent tax year, precedential authority allows FTB to charge interest on the deficiency assessment starting on the due date of the subsequent tax year's return. Again, April 15 is the key date. Here, appellants made an irrevocable election to convert their 2017 overpayment to an estimated payment towards 2018 tax liability. Then when they filed their 2018 return and elected to have another overpayment applied towards 2019, that's what they did. At that time, the original 2017 overpayment was no longer held by respondent for appellant's 2017 account, and interest properly began to accrue on the 2017 deficiency, the entire $2 million, starting on April 15, 2019. Again, there's this, the question of whether this cutting the overpayment off on April 15, 2019, and at that point they don't have the money, that's just not true, and that is what we need to, that's really what's at issue in this case. And again, 19101 makes, and the interest provisions make no mention of any of these statutes. That's important because, you know, there's confusion in between the estimated regime and tax payment and interest. Okay, so those are two passages from the FTB. That's the crux of their position. Let me read from a couple cases that are directly on point. This is Otis. Yeah, I'll get there. This is Otis Spunkmeyer from 2004, Northern District of California, federal case. Okay. And the federal statutes are effectively the same, which, you know, they're citing federal cases, we're all citing federal cases because they're pretty much the same. So this court in Spunkmeyer says, court turns next to the one true issue in this case, the merits of the theory upon which the IRS charged OSI interest from March 15, 1995 for the 1993 tax year deficiency, and March 15, 1996 for the 1994 tax year deficiency. Again, IRS was applying the same theory here, which is that you cut off this overpayment balance on April 15 of the subsequent year. We'll get there in a minute. The IRS contends that Code Section 6513D, which is the same as the credit elect we'll get to, and a revenue ruling govern the resolution of this question before the court. More specifically, the IRS contends that these provisions render OSI's tax unpaid as of March 15, 1995 for the 1993 tax year, and March 15, 1996 for the 1994 tax year, because on these dates the respective overpayment credits were deemed by the IRS to be tax payments for the succeeding year. It's exactly what the FTB is saying here. The IRS argues, this is on the next page of this case, the IRS argues that under 6513D, a credit elect assigning 1 year's overpayment to the next year's tax liability effectively transmutes the overpayment as of the date of the subsequent year's tax return into a tax payment for that year. At that moment, the IRS argues, any prior year underpayment becomes unpaid and the IRS is entitled to begin charging interest as of the date the tax was due. The court in this case disagrees with that and explains that that's not how the law works. The taxpayer in this case, like our case, had an overpayment balance at the end of that succeeding year, and so the government, there is no statute that allows, like the credit elect statute we'll get to in a minute, nothing in the interest statutes allows, or the credit elect statute, which doesn't apply to interest, allows you to treat an overpayment balance that exists on April 15 as no longer there. We all agree that it's there, and this 19101, it keys off of whether there is tax due and unpaid of that date. There isn't. What's important in Otis and some of these other cases, they take a step back and they say, look, you have to look at the context of these code sections. Just like here in the federal, in the federal cases that were in the federal law, there is a chapter dealing with interest. There is a chapter dealing with deficiency assessments. There is a chapter dealing with an estimated tax payment regime. They are separate. And what the court in Otis says in other cases, that you have to look at, when you look at the structure and the context, you can't import, there's nothing in this credit elect statute and nothing in the interest statutes that, where they apply together. So we'll come back to that. Again, the court, so they say in Otis, for example, first, while the IRS relies on section 6513D, this credit elect statute on the federal side, when reviewed in its proper context, is not concerned with the assessment of interest. It's concerned with, period of limitations. Okay, time when tax is due and deemed paid. So again, in this, in Otis, the court is going to, I'll come back to what they hold, but they reject the FTB's argument in this case completely. And that's fine. The only issue in this case, by the way, is whether interest, the FTB's position is interest accrues on April 15, 2019. It can't, because on that date we had an overpayment. And certainly it can't accrue on the entire amount of this deficiency, because that's already been satisfied even on their own Exhibit C. So why is this difficult? Why is, again, even the protest hearing officer and these computations on the NPA and the NOA, they're wrong. They have to go back and recompute this and figure it out. In this case, they didn't do it right. They're just thinking that, like in the IRS and Otis and in Goldring, another case, that this credit elect provision automatically somehow treats taxes that are overpaid on the as of the end of the succeeding year as now no longer available. But they have the use of the money, so they have the money. 1123. Okay, sorry. Goldring, which is also on point. Otis is directly on point. Goldring is also directly on point. I don't want to get into the authority issue. The cases, there's a progression of cases. Avon, May, Fleet Boston, Otis, Goldring, they have different factual circumstances. Otis and Goldring are both directly on point here because, like in this case, the taxpayers were fully overpaid going into at the end of the succeeding year, which in this case was April 15, 2019. That's not always the case in the other ones. And the earlier cases and revenue rulings that the IRS had, which are then kind of distinguished or explained why they're not completely right in Otis and Goldring, are sort of a progression. So when you get to Otis and Goldring, they're directly on point, and talk about Avon and May completely. Okay.
Mr. Campbell, just letting you know, my timer shows you have like 5 minutes left. Is that okay?
Jeez, I went too slow. Okay, thank you. So, okay, I'll conclude at this point, and then the FTB can go. But the point is, let me find the estimated. I have to talk about the estimated payments. Where are they? FTB cites one statute in its brief, which is 19134. Sorry, 19364. This is the provision that says, if any overpayment of tax is claimed as a credit against estimated tax for the succeeding taxable year, that amount shall be considered as payment of the tax for the succeeding year, and no claim for credit or refund shall be allowed for the taxable year in which the overpayment arises. And that section is also, there's other provisions that they didn't cite that contain that same language that are in the claim for refund provisions in Article 1 and in, like payment, penalties. And none of this, again, in the interest statute in particular, 19101D even, D says, this is the interest statute. This articles shall not apply to any failure to pay estimated tax required by section 19136. So the statute cited by the FTB, 19364, along with the estimated estimated tax regime, are in separate provisions and just don't have anything to do with interest by the express interest statute. Is it okay if I go over by a couple minutes? Do you mind? Just, and then you can, you'll go through these statutes too. But I think what's important here is that there is a separate regime. We incorporate in 136, the estimated tax payment regime, and then it's modified in California under 19136.1. That regime requires you to pay in installments certain amounts so that your tax is fully paid by April 15 of the next year. In those statutes, we can get to it in rebuttal, or maybe they'll go through them, but those statutes provide, and the credit elect statement says, every time you file your return, if there's an overpayment, you can either choose to have it refunded, get a check back, or you can credit it towards these installment payments that are coming for the next year. And in our case, we elected that every year. And in Otis and in Goldring, that's what happened. And in these other cases, for the most part, that's what happened. This statute, 19364, and the language that says no claim for credit or refund shall be allowed for the taxable year in which the overpayment arises. 19363, all estimated taxes shall be deemed to have paid on the last day prescribed for filing the return. Again, April 15, everything is applied. The FTB agrees with that. It's not in dispute. The point is, you can't ask for a refund of estimated taxes of your overpayment until it's applied the next year. But once it's applied, you can certainly ask for a refund. But that amount is sitting there, and that's the point in Otis and Goldring in these cases. They're saying, look, interest runs when there's tax due and unpaid. Tax is applied in all circumstances and determined whether there's an underpayment or an overpayment on April 15. The separate regime, again, interest does not apply when there's an underpayment of estimated tax. The entire point, and I apologize if I'm going fast, of the installment payment system and estimated system is at the end of the year, and you self-assess or you determine whether you have an underpayment penalty. If you have underpaid the installments, then a separate statute in this other regime says, hey, you don't have interest, you have a penalty, okay? And in IRS, there's 4 quarters that you have to satisfy. There's different methodologies for determining whether you've paid enough. You can't make any of those determinations until April 15, by the way. So at that point in time, that's what this credit elect relates to. I'm electing on my return to move this forward. At the end of the next year, I'm going to figure out, whether I owe an underpayment penalty and whether my tax is overpaid or not. But none of that has to do with interest, and that's exactly what the Otis court said and Goldring said. And so the question I would ask is, sorry, I know I had it. Whether interest can accrue. What is the statute that allows interest to accrue in this case on April 15, 2019, which is what 19101 says? And what is the statute that allows this credit elect provision to cause interest to begin to accrue on April 15, 2019. There is no connection between the concept of each year applying your overpayment to satisfy estimates that are going to be, determined whether there's an underpayment later, and the fact that the FTB has your money in the meantime to satisfy any underpayment that might later, come into fruition. And that I'll just leave you with Goldring. sorry, I'm analog, so, I look at paper, as Chris said. In Goldring, same as Otis, the government's argument in this case fixates on the theoretical migration of credit elect overpayment funds from one tax year to another. However, this argument completely ignores the simple, undisputed fact that the IRS was never deprived of its use of the money the Goldrings lawfully owed at any point during the 5-year underpayment interest assessment period. That's the same here. And really the focus again is on April 15, 2019, because that's the date, that's the argument the FTB is making, that on that date, this credit elect theoretical migration treats whatever overpayment exists as no longer existing and reinstates the entire deficiency. That is wrong. There's no way to read the statutes to get there. So that would be my question is, how do you get there? Lastly, I see their visual. I think they're going to talk about some revenue rulings which are distinguished in Otis or discussed in Otis and Goldring. And the point is, the situations in those rulings, what's different here is that we are completely overpaid. There's no question, as of 4/15/2019. So we're all in agreement. So that again should be the focus, is what's the status of our account, so to speak, on 4/15/2019. And we're happy to pay interest. Again, we make a payment. We know we're deficient at that point in time in 4/15/2020, and that's how we computed our interest. So good? Okay, I'll stop here.
Okay, thank you, Mr. Campbell. I'll turn to the panel now to see if there's any questions. Judge Turner, did you have any questions?
Yeah, I think I actually have two. Is it your position that there isn't, the FTB's miscalculation of interest is because there was not an amount unpaid under Section 19101, or identified other statutory limitations on the imposition of interest, 19105, 107, 108? Is it your position any of those specific statutes apply? Or is it simply that under 19101 there isn't an amount not paid until April 15th of 2020?
That's a good question. I mean, the answer is 19101 answers the question because there isn't an amount unpaid. However, those statutes support the point. I think it's 19108, and I just wanted to find it, where is that statute? Give me 1 second. Again, there's 19108 explains that no interest shall be assessed on a portion of a deficiency from 1 year that's extinguished by a credit for a period of time subsequent to the date an overpayment was made. So I won't get into exactly how that applies, but the point is these provisions, like you cited, in addition to the plain language, which clearly applies to us, when you look at the whole scheme, these statutes are saying that the FTB, or that we must move money that is overpaid to satisfy deficiencies, and no interest can accrue. And all of that just goes to say, again, when you look at the whole scheme and read the Otis and Goldring in particular, you can start with Avon and May for sure, but that if you have an overpayment as of an April 15 date, you can't start interest on that date. So you have to look to the next April 15 each time. And that's when you measure, whether you have an overpayment or not. Does that answer the question?
Yes.
Okay.
Second question. We've talked about the use of money, the overpayments being available for the FTB or the state to use. What does it mean to have the use of money?
Good question. So in our briefs, we use the term use of the money principle, right? So in hindsight, looking back, again, this is why I'm taking a lot of time to go through the statutes. That's a label, and the label isn't really helpful unless you understand what the statutes say. So use of the money just means, in general, interest, general principle, stated in all of these cases, that if the government has the use of the taxpayer's money, the taxpayer, to cover all amounts, due as tax at that point in time, they can't assess interest. Just like, and so, it just makes sense. If the FTB's got an extra $100,000 of mine, and then it's later determined I have $100,000 that I owe at the same time, I shouldn't be charged interest because they actually have the $100,000. And that's exactly what the case is here.
I guess a follow-up to that
Yeah.
then is, when you say use, is it specific then to a tax liability, or is there some expanded use that the courts are referring to when they're talking about use of money?
No, I think, well, that's why it's a label. And I think when you look at Avon, May, Fleet Boston, Goldring, Otis, and all the other cases that are cited, it's just a description of the concept that you don't charge interest and you shouldn't be assessed interest if there is enough money, if there is amounts that you've paid that are more than an amount that you owe. In this case, the specific statute that we're applying is 19101. That statute is the statute that imposes interest. You don't have interest unless you apply 19101. 19101 tells you when interest begins to accrue. It only is on April 15. It's only if you have an underpayment or not an overpayment on tax due and unpaid on April 15. Avon says that, May says that, and it continues. We all know that April 15 is the measuring date for this point. So the use of the money, in this case, it's just a label, but when you look at the statute, we are talking about, have you paid tax, sufficient tax on April 15? And in this case, we did until April 15, 2020. That's it. And you got to look. It's talked about. It's the label that all the cases use that we use high level, but it's has a specific meaning in each of these cases when you apply the law.
Thank you.
Make sense?
Yep.
Or did I answer? Okay.
Okay, thanks. And Hearing Officer Elson, did you have any questions?
Hi, Mr. Campbell. I did have two questions. And the first was that you had made the point that FTB's own schedule in Exhibit C applies the overpayment against the $2.2 million liability. And this appears to be only for the calculation of interest. And my question is, did you have any discussions internally, review any law or any legal authority to apply that deficiency against the overpayment and simply recalculate the overpayment credit rolling forward? In other words, did you ask why the Franchise Tax Board didn't simply recalculate the overpayment to $1.4 million and just roll that forward?
Yes, during the protest, and if you look at the exhibits, I think the protest correspondence is mainly attached to the FTB's appeal. Not only is there back and forth, written communication, but there's references to telephone calls and meetings, and so that entire process, as you'll see, is our protest started with, you are not taking into account overpayments. You need to recompute it. And they are then providing us interest computations and explaining with citations to Avon and May and stopping there, and their interest computations to say that, here's how we do it, and this is how we do it, and you're wrong. And the reason we're doing it is because of, as we read these cases in a revenue ruling, you have to apply the amount that you have overpaid towards and treat the these estimated tax installment payments as being satisfied. Now we explain to them that doesn't even make sense, because under their own determination, when they do that, as you said, they spring the entire deficiency back on April 15, 2019. So even under that theory, it's not, it doesn't seem to make sense. I don't know if that fully answers your question, but yes, we absolutely discussed it, and that's the whole point of the difference between their computation, what they say in their protest determination letter, and their brief, when I read that passage before, which I think relies on like Avon and May mainly, and our position, which again relies on the statute and the later cases, Otis and Goldring, that expound on all that.
So as a follow-up question to that, did appellant ultimately pay the deficiency balance on March 22nd, 2021 to prevent the accrual of interest, or were they conceding on that, a calculation of overpayment credit?
A good question. As our if you look at the table, again, we all agreed that we owed 2.269 million back for 2017. The amount of, and so we paid that on March 22. When we paid that, we were then again overpaid. It didn't just bring our balance to zero. So on the, each year on the date you determine whether interest begins to accrue April 15, you can see that after applying the $2.269 million payment to 2017 and 2018, we still have an overpayment of $761,000 on April 15, 2019. On April 15, 2020, that results in our actual tax paid to be underpaid by $1,040,000. So as we see it, the statute says, we pay interest starting on April 15, 2020 on the amount that is still unpaid. Does that answer your question?
Yeah, I believe so.
Okay.
Second question is regarding the schedule that the Franchise Tax Board provided in Exhibit C. I just want to clarify that there's no dispute on the interest calculation there, and you'd referenced the Franchise Tax Board's application of portions of the overpayment credit to estimated quarterly payments. And I wasn't completely clear if you were just drawing a distinction between how it should be applied, how the overpayment should be applied, meaning end of the, when the tax is due for the following year, or if you had any dispute with actual interest, because it appears that there's no interest charge for that period. So I just want to be clear on that.
No interest charge for which period?
For the period of 4/15/2018 through 4/15/2019.
That's correct. We all
Okay.
agree that no interest is assessed or due for that period.
Okay.
Because we were overpaid from 4/15/2018 to 4/15/2019. The issue is on 4/15/2019, when we're still overpaid under their theory, they begin to assess interest on the entire amount, of the 2.2 million, which is just not correct.
Okay.
That's
And then just a quick follow-up. Again, this is just computational.
Yeah.
It appears that FTB applied the overpayment credit to quarter 1 and quarter 4 in that context of that schedule. And was that because appellant had separately made quarterly payments for quarter 2 and 3?
Well, you always make payment. Yeah. So if you look at the bottom of their schedule, and this is, if anything, I think just the confusion and the difficulty in doing this should lend itself to the correct reading of the statute here, because all of this is extremely difficult to follow, and it has to be done in hindsight, right, and over again until it's fixed. So what they're doing here, and you can see they have required estimated payments down at the bottom. They have this whole table. Those are the amounts, and again, the requirements are not known until April 15 of the next year, because that's when you can determine what percentage you should have paid at each quarter. And you self-assess a penalty if it exists, not interest. So they're putting in the requirements here on this first line, as well as amounts that we paid in to satisfy those requirements, and that's what they're debiting or taking into account in that right-hand column, to use it up, so to speak, which gets them to negative 880, which gets them to an overpayment of 889,000 as of, I think, April 15. May pause. Am I answering your question? Because they are applying it. I'd have to go back and study this particular chart, and maybe they'll go through it, but that's what they're doing. Their view is they take the 1,490,000, which we all agree is the overpayment, and they start applying it against installments that are due and saying that that's no longer available. But they say it's no longer available only a year later, as of April 15, 2019. That's the issue in this case, and that's the very specific issue dealt with in Otis that I want to draw your attention to, because it gets very confusing otherwise, but that should be the singular focus. That if you look at that, you say, wow, how can that all just disappear, and all of a sudden they say I owe, again, 2.269 and I have to pay interest on it. So I'm not disputing, their interest, they computed, I think, 240,000. We paid it to satisfy. But again, our self-assessment was about 37,000 on the right way to do it.
Okay. Yeah, okay. I believe that answers the question. Thank you.
Okay, thank you. I don't have any questions, but I was wondering if the parties were okay with taking a break for lunch and then returning at 1 if that works, and then we could finish with FTB's presentation and questions and then closing. Does that work?
We just have some travel arrangements that would need to be changed if that were the case. I think it would be our preference to maybe power through it, but if OTA would like to do that, then we have no objection.
Well, I think there's 30 minutes left for FTB, then questions. So it probably seems like it might take 45 minutes, 50 minutes. I guess, how about we take let me just talk to the hearings of people. We could take like a 5-minute, how about like a 5 or 10 minute break? How about 10 minutes? Does that work then?
Sure, yeah, that's fine. And I don't think we will utilize our entire 30 minutes.
Okay.
It will come in quite underneath that.
Okay, cool. That sounds good. We'll just go off the record then and take a 10-minute break. Be back at 11:50. Okay, is everyone ready? Ms. Alonso, are you ready? Yes, sir. Okay. Mr. Campbell, are you you ready?
I'm ready.
Okay. So we'll go back on the record. And at this time, FTB, Mr. Cook, you can proceed with your presentation. You have 30 minutes.
Thank you, Judge Lambert. Good morning. It's still morning. I'm Chris Cook. With me is Jackie Zameda. We are representing the FTB in this case today. We plan to discuss 2 issues today. First, we will address whether OTA has jurisdiction to consider the interest calculation on a deficiency assessment when there is no dispute that the deficiency is correct. Then we will discuss, on the assumption OTA has jurisdiction over the interest on the undisputed deficiency in this case, whether FTB followed the law when it calculated interest on appellant's 2017 tax deficiency. We begin our discussion of the first issue by noting that we all agree that the OTA's rules for tax appeals at Section 30103A1 states that the OTA has jurisdiction to hear and decide an appeal when, as in this case, FTB mails a notice of action on a proposed deficiency assessment of additional tax. We can also agree that under the same regulation, an appeal of a deficiency assessment may also include penalties, fees, and interest. But the issue today is that the Revenue and Taxation Code and prior Board of Equalization precedent is quite clear that the interest charge on a deficiency is by itself not a deficiency. Section 19043A of the Revenue and Taxation Code defines a deficiency as being the excess of the amount of tax the law imposes on a taxpayer less the amount of tax shown by the taxpayer on a return. Thus, a deficiency as defined by statute does not include interest. Since interest by itself is not a deficiency, the OTA does not have jurisdiction under the rules for tax appeals to make a decision on interest when there is no deficiency. The OTA's predecessor, the Board of Equalization, said as much in its 1995 decision, and I hope I pronounced this right, Appeal of Nicholas Shalas. The BOE stated, and I paraphrase, because interest is not a deficiency, this board does not have the subject matter jurisdiction over questions relating solely to unpaid interest on a deficiency. So the proper avenue to appeal FTB's interest assessment when the related tax deficiency is not in dispute is to pay the interest and file a refund claim with FTB. If FTB denies the refund claim, the OTA does have jurisdiction to hear and decide an appeal of the refund claim denial under Section 30103A3 of the Rules for Tax Appeals. In this case today, FTB's records show receipt of payment of the FTB's interest computation on June 22, 2022. The payment was received before FTB sent the notice of action on June 27th and before the OTA acknowledged receipt of appellant's appeal on July 26th. While the notice of action enumerates the underlying tax deficiency along with interest, if appellants are not challenging the tax deficiency, then the notice of action is not the vehicle to get a hearing with the OTA. Since the action in this hearing today is an appeal of a notice of action and not an appeal of FTB's action denying a claim for refund, FTB asked the OTA to consider dismissing this case. Moving on to the next issue, that is assuming OTA does have jurisdiction to consider the interest on an undisputed deficiency, we will start by repeating the long-standing federal precedent that California follows that interest begins running when a tax becomes both due and unpaid. Also, each tax year stands on its own. On their 2017 tax return, appellants reported an overpayment of approximately $3.8 million, which they requested be applied to their 2018 estimated payments. Approximately $280,000 of this 2017 overpayment was used for the 2018 first quarter estimated payment, and approximately $321,000 was used for the 2018 fourth quarter estimated payment. When appellants filed their 2018 tax return, approximately $3.2 million of the 2017 overpayment remained. Appellants used this remaining $3.2 million as payments applied to the 2018 tax year, which then created an overpayment for 2018. Appellants elected for this new overpayment to be used for 2019 estimated tax payments. Under Section 19002E of the Revenue and Taxation Code, overpayments that taxpayers request to be credited to subsequent estimated payments are considered payments for the subsequent year and cannot be refunded or credited for the year for which they arose. This means that under the law, when any portion of the $3.8 million overpayment from 2017 is used to satisfy 2018's estimated tax payment, the amount used cannot be used or refunded to 2017. Under Section 19363 of the Revenue and Taxation Code, any payment for estimated tax is deemed paid on the tax return filing deadlines for that year. Under Section 19364, overpayments credited against estimated taxes are deemed to be payments for the succeeding years and cannot be credited or refunded to the year they arose. And again, under Section 19002E, a taxpayer may claim a refund for overpayment in a prior taxable year until the date that the overpayment is claimed as a credit for a succeeding taxable year. So appellants' election on their 2018 tax return to apply all of the 2017 overpayment to 2018 was deemed a payment to 2018, and there ceased to be an uncredited 2017 overpayment as of April 15, 2019. Appellants agree with the determination on FTB's Notice of Proposed Assessment and Notice of Action that the reported 2017 tax was underreported and underpaid by approximately $2.3 million when the 2017 tax was due on April 15, 2018. Under Section 19101 of the Revenue Taxation Code, interest is charged on the underpayment of tax from the day it was due until the underpayment is paid. But in cases like this, where an overpayment was created in a year that is subsequently adjusted by audit, FTB follows the federal case precedent, May Department Stores v. United States, as well as the applicable IRS guidance and Revenue Rulings 99-40. The rule under these authorities is that when an overpayment is created any tax year and elected to be applied to the subsequent year, then interest is not charged on the later determined deficiency until the overpayment is applied to the succeeding year's estimated payment. FTB corrected its interest computation upon appellants' protest of the MPA to comply with these federal standards and with the Revenue and Taxation Code. Hopefully this handout was, you can refer to this and this will be helpful to show that, thus as corrected, the law dictates that appellants are not charged interest on their underpaid 2017 tax until the 2017 overpayment is no longer available to be applied to 2017. Again, by law, the 2017 overpayment was no longer available when it was applied to 2018's tax year estimated tax payments. Appellant's 2017 overpayment sufficiently covered both the 2017 underpayment and 2018's estimated payments. Therefore, the 2017 underpayment is not charged interest while there was sufficient uncredited overpayment balance still creditable to 2017. But when appellants elected for the remaining overpayment balance to be applied to 2018 payments on their 2018 tax return, then by operation of law, there remained no more 2017 overpayment that could cover the 2017 underpayment. Since there was no money remaining to cover 2017, interest began being charged beginning April 15, 2019. So in summary, April 15, 2019 is the date appellates elected to apply the entire 2017 overpayment to 2018 taxes and elected the resulting 2018 overpayment to be applied to 2019 estimated taxes. So no more 2017 overpayment existed after this date. Appellant's argument in this case is that FTB and OTA should ignore that the 2017 overpayment was credited to 2018 and reported on the 2018 return as contributing to the overpayment, and elected that a new overpayment be applied to 2019. Appellant's argument is that the 2017 overpayment really became part of sort of a prepayment applicable to all tax years, kind of a pool of money sitting in reserve to be applied to any tax payment in any year as needed. While this would no doubt be convenient, this is unfortunately not how the Revenue Taxation Code and related federal authorities treat monies as being applied to different account periods. Once appellants claimed all the overpayment as 2018 payments for use in 2019 on their 2018 tax return, the government was no longer in possession of the funds that could be used to satisfy the 2017 deficiency. So FTB followed the law in determining that no interest is charged from April 15th, 2018 to April 15th, 2019. And FTB followed the law in determining that interest is charged from April 15th, 2019 until the deficiency was paid. Therefore, assuming the OTA has jurisdiction to decide on this issue, FTB asked the OTA to sustain FTB's interest calculations in this case. Thank you, and I'm happy to answer any questions.
Thank you, Mr. Cook. I'll turn to the panel now. Judge Turner, do you have any questions?
The FTB. So if a taxpayer disputes the calculation of interest on a refund, but the FTB concedes to the refund, is the determination of that calculation of interest within the jurisdiction of OTA? And how would you reconcile? Yeah, we'll start with that.
A refund claim is a separate action
Understood.
to be brought to the OTA than an appeals claim. So in that situation, the taxpayer had filed a claim had paid the interest amount, had filed a claim, FTB denied it, and so it's like any other refund claim action at that point.
No, I guess my question was if the taxpayer filed a claim for refund, and but there was and the FTB agreed with the amount of the refund. There wasn't a dispute over the claim for the refund itself, but there was a dispute over the FTB's calculation or whether or not interest was due on that refund at all. Would that question be within the jurisdiction of the OTA?
Oh, if there's interest due on a refund to be
Correct.
to pay to the taxpayer.
Correct.
If it's a refund claim, any taxpayers are allowed to, file a refund claim with the FTB, and once that's denied, that's their ticket to the Office of Tax Appeals.
I'm not talking about the substance of the claim. I'm talking about specifically the calculation or determination of whether interest is owed.
Yes, if they've paid it and they filed a refund claim and it was denied.
Okay.
So I would add that typically on a claim for refund action at OTA, OTA's opinion addresses the substantive issue, and then FTB subsequently determines the amount of the refund that should go out, which is the substantive amount as determined by OTA, in addition to the statutory interest that FTB would owe the taxpayer. So typically in a claim for refund action, OTA, the taxpayer nor OTA would be advised of what the interest amount was beforehand, because it all depends on when that refund claim is paid out. So it may take FTB 3 to 4 weeks to be able to close it out after the opinion goes final. At that point, we would owe interest to the taxpayer until the refund was actually issued.
Okay.
Okay, thanks. Hearing Officer Elson, do you have any questions?
Hi, I did have one question, and maybe there's not a simple answer to this, or maybe it can be addressed. The 2017 overpayment balance, it also has an overpayment credit from 2016 to 2017. And you had made the point that appellant essentially has a pool of funds that applied against any year until they're exhausted. Isn't the application of 2016's overpayment credit rolled into 17 and then to 2018, isn't that the same concept? In other words, you could have overpayment credits from previous tax years that continue to roll forward until they're actually applied. Could you address that, or have you any position on that?
Yes, that's how the law works. Once they claim it on their return as part of their payments for the tax year, and the remaining overpayment balance they elect to apply to subsequent year's payments. So at that point, that 2016 tax year overpayment did become, was part of 2017, and then when it was claimed as part of 2017's payments, it became part of that overpayment for that year.
Would the 2016 tax year affect the calculation of interest, though, in 18? Let's say there was a deficiency balance in that year. In other words, appellant would like to roll forward the balance from 17, and you're stating, each year stands alone. If there was a deficiency in 18 and that 2016 overpayment credit is essentially baked into that balance that's rolled forward, would that affect the calculation of interest?
If they had an overpayment balance as of the the end of the subsequent tax year that was created by the subsequent tax year, each tax year stands alone. That 2016 overpayment is not a 2016 overpayment anymore. It's now a 2017 overpayment. Does that help?
Yeah, like I said, I'm not sure if there's a simple answer to this, but that's good. Thank you.
Thank you.
Thanks. I don't have any questions, so at this time we could move to the closing remarks for Mr. Campbell. And before we had stated 10 minutes, do you still need the 10 minutes, or? Okay, we'll just go with 10 and for now.
Okay, let me start with jurisdiction. And Judge Turner's question was a good one because it illustrates, the question was a good one because it illustrates that, again, their argument here hinges on the existence of a deficiency before the OTA, but there is nothing in the jurisdictional statutes that requires there to be a deficiency. That's just not a germane argument. So 30103 A1, again, jurisdiction keys off of FTB mailing a notice of action on a proposed deficiency assessment of additional tax, which may also include penalties, fees, and interest. The other sections interest is assessed and collected as tax. Again, bottom line is it's on a proposed deficiency. It doesn't depend on the existence of the deficiency at the time, that this appeal is filed. And to your point, if they agreed on the amount of a refund, and the interest computation was incorrect, obviously we're saying you have jurisdiction. It seems, and it can't be the case that just because a deficiency or a refund, the amount of tax in dispute has been agreed to, that you no longer have jurisdiction. I'm actually surprised because it seems like we all agree that if the tax remains in dispute to some extent, then you fully have the jurisdiction to apply these statutes and determine the correct interest computation. So, again, I would just say, please look at the statutes, and there's nothing in there that hinges your jurisdiction on the existence of a deficiency. That's just not what it says. They mail a notice, they've made a determination, that's what's before you, and all those different things, which several of them include interest too. By the way, in our letter in October 5, we cited several cases where the board and the OTA have reviewed interest computations, at least one or two of which, Kraft and another one, there was no disputed tax at the time of the decision. So I don't think jurisdiction, I think we would find that you have jurisdiction. The Schillis case is an abatement request case as well. It's not one or the other. Yeah, that's okay. Okay, on the merits, again, I think, Judge Elsom, your question was a good one. First of all, the concept that each year stands alone, that's just a general principle in tax, that every year you determine for that tax year what your income is, what your deductions are, and you file a return. That has nothing to do with anything else. It's just a nice comment. It doesn't have to do with these statutes. The key is their argument, as you just heard, completely depends on the concept that when you elect to have an overpayment transferred to another year under 19002 and 19364 and 19363, these provisions say that you can't ask for a refund until the next year when everything is applied. As the cases like Otis and Goldring say, which are directly on point to these facts, where we have an overpayment balance at every April 15, there is no question, there's no statute that allows you to impose interest on the amount of tax due and unpaid on those dates. The concept of a credit elect is, where's my comment on that? Sorry. By the way, so the concept of the pool of money, excuse me, if you look at the claim for refund article, 19300 through 19368, for example, those provisions say that the FTB, on their own initiative, if they find that there's been an overpayment of any liability, the amount of the overpayment may be credited against any amount then due. There are several provisions in the claim for refund section that allow the FTB on its own determination to move money to satisfy amounts due for prior years or subsequent years. And then there are specific sections in that same article that say a taxpayer has to file a claim for refund in order to start that process. So they have to file, the FTB can do it on their own initiative. All of those statutes, Article 1, claim for refund, the estimated tax payment requirement, which actually comes into the code through the refund and overpayment section, where they incorporate the IRS rules. None of that, as the courts in Otis and Goldring explain, there is no connection between the interest statutes and those statutes. And the FTB has not provided any authority in its discussion or in its briefs to connect the imposition of interest in 1901 with the credit elect / estimated tax regime, because there just isn't one. And again, the interest statute itself, 19101D, says interest doesn't apply to underpayments of estimated taxes. There's an entire separate regime that says, we're measuring those on these installment dates when everything's applied at the end of the year. It's always in hindsight. And we will determine if there's an underpayment, and we will charge a penalty, which is effectively like interest, but it's separate. So you have these two parallel tracks, and they're just not connected, and that's just very clear here. And again, I would just focus, lastly, to remind everybody that the issue in this case is they're saying that under the law, which I'm still not sure what the statute is that they're relying on, that this overpayment that exists clearly on their own schedule disappears on April 15, 2019. And not only does it disappear, the entire $2.269 million reappears as due on April 15, 2019, such that interest can accrue on that amount. I find no statute that says that does that. The cases say that that is wrong. I mean, the language I read from Otis and Goldring earlier. So I think their position has been, asked and answered by the courts. There's no connection in those statutes, and in this case, on these facts, we can't have interest accrue on 4/15/2019, and that's really the end of it.
Okay, thank you, Mr. Campbell. So if there's nothing further, I'm going to conclude the hearing. I want to thank both parties for appearing today. And we will issue a written opinion within 100 days, and the record is now closed. The next hearing will be at 1 p.m. Thank you.
Thank you.
Thank you, members of the panel.
Thank you.
Thank you.